My name is Jeff Morgan. I am from Dallas, Texas, and I've been reading this defendant's motion to dismiss. It comes out of Berkshire County, and this is in Massachusetts, Commonwealth of Massachusetts Probate and Family Court Department. Here is Berkshire County. The docket number is BE20D0220DR. Marcia M. Delmeyer, the plaintiff, versus Mark E. Delmeyer, the defendant. And this is the defendant's motion to dismiss. Here's the introduction. Comes now Mark E. Delmeyer, the defendant in the above captioned matter, and hereby moves to dismiss this case pertaining to alleged grounds of irretrievable breakdown of the marriage. The case arises out of the plaintiff's desire for a unilateral no-fault divorce, a unilateral no-fault divorce, a forced divorce, divorced on demand, divorce against which there is no type of defense. And yet Mark Delmeyer is actually raising a case here that he says the plaintiff wants a unilateral no-fault divorce, and the defendant contests it. So this is a very interesting case to watch, because typically what happens in the case of unilateral no-fault divorce, unilateral means only one person wants it, one person can file for it, one person gets it. That's just the way that it works. And he's trying to say, wait a minute, I do not agree that there is an irretrievable breakdown of this marriage, and I am contesting the unilateral no-fault divorce. Unilateral no-fault divorce is tyranny in the strictest sense of the concept and the word tyranny. When you go into a court and a judge looks at two people because one says, I want a unilateral no-fault divorce, and automatically grants it, and makes the other person, deprives him or her of legal rights. Because you see, when you get married, you have certain legal rights that are part of the marital estate. The judge will take those legal rights and say, the hell with them. We are going to grant your spouse a unilateral no-fault divorce, and there's nothing you can do about it. This is so tyrannical, yet most people, most states, everybody doesn't even, very few people actually think about what takes place with unilateral no-fault divorce. And as I've mentioned many times in the past, unilateral no-fault divorce in the 20th century was implemented in Bolshevik Russia by Vladimir Lenin. He was the guy that took over Russia. He overthrew Russia, established Bolshevik Russia, and one of the first things that he knew he had to do in order to help establish communism in the country was to destroy marriage and weaken the church. How did he do this? First off, he said that church marriages no longer really account for anything. All marriages are civil marriages, so the church has lost its authority and its power in that area. And the second thing he went to was the issue of unilateral no-fault divorce. Why was that? A father, you kick a father out of the house, you break down the family, you have a society that is more susceptible to being manipulated. The interesting thing about that, and this is from an article in July of 1926 in the Atlantic magazine, is that after this took place, the consequences to Russia were so severe that even the communists were saying, what do we do about this issue of unilateral no-fault divorce? Abortion had spread like wildfire throughout Russia. You had orphans, you had people that were addicted. You had men that would hook up with a woman just to have sex and then leave her heartbroken, just like that. There was no legal protection for the institution of marriage. And for Vladimir Lenin and for the communists, that was okay. What really mystifies me, however, is that in the state of Texas, we also permit this. We have taken the communist, Bolshevik, Russian, Leninist doctrine of divorce, and that is our official divorce policy for the state of Texas. 6.001 of the Texas Family Code talks about insupportability. Insupportability is nowhere defined. All a person has to do is allege insupportability, and the person who is the respondent has no defense. The divorce will be granted. His or her house may be taken away. He or she may not be able to see their kids on a daily basis. They may have to pay bills. Child support. Oh, we have this child support stuff going on right now. Yes, we need to have divorce so we can collect some good child support. Even if you're divorced against your will, you may have to pay child support to the person who may be filing for unilateral divorce because he or she is in an affair. It makes no sense whatsoever. But I'm very glad to see Mark Delmeyer is actually contesting this unilateral divorce. 12b, this case may be dismissed for the following reasons. Number one, failure to state a claim upon which relief can be granted, and lack of jurisdiction over the subject matter. the defendant categorically denies the allegation that the marriage is irretrievably broken and contests this cause of action for divorce. In doing so, the defendant challenges the constitutionality of unilateral no-fault divorce law in that the statute requires the court to discriminate between viewpoints, namely whether the marriage is irretrievably broken. The state statute in question is GLC 208 Section 1B. This motion requests the dismissal of the case in its entirety since there are no outstanding triable facts as to the underlying cause of the action. Remember, this is an allegation. No evidence is necessary in unilateral no-fault divorce. All you have to do is say, I believe that the marriage is irretrievably broken. There may be no reason for the belief, but somehow in that person's mind, or maybe because the person wants to use that because they can say, well, our marriage was broken, and really he or she does not want to fix the marriage. It gives them a convenient excuse which they can hide behind because our legislature, and this also occurs in the state of Texas, has given them a perfectly valid reason to file for divorce, to get a divorce, and to not take blame for anything that goes on in this. The motion requests a dismissal of this case in its entirety since there are no triable facts as to the underlying cause. The first question before this court is whether GLC 208 Section 1B confers legal standing upon the plaintiff. The second and ultimate question before this court is whether GLC 208 Section 1B is a viewpoint-based statute that communicates and or endorses a government-sponsored preference for the outcome of divorce proceedings in favor of the plaintiff. Everything else is a derivation of these two questions. The arguments presented here too involve pure questions of law. This again is very important because what's happening here is that the court is going to grant a divorce based on the viewpoint of one person who says our marriage is irretrievably broken. I think it's very interesting that this case is actually taking place in Massachusetts right now, because last year there was a case, Shurtleff versus the city of Boston. In this case, Shurtleff had a flag he was trying to get flown by the city of Boston. The city of Boston would not let him fly the flag because it had religious symbols. This case made it to the Supreme Court, and the Supreme Court unanimously 9-0 ruled that Boston had engaged in religious viewpoint discrimination. Religious viewpoint discrimination. This is talking about whether the statute here is based on viewpoint discrimination or not. Viewpoint, again, being that the state will always side with the person who wants a divorce. There is no defense against the viewpoint. My viewpoint may be different, and the state says, we don't care. We already have a predetermined outcome that will take place. There is no recourse, no remedy at law. Unilateral divorce means only one person gets to do it. And somehow we think that this is just. Somehow we think that this is right. Somehow we think that the due process is not being trumped here. Actually, in every aspect of it, it is. The issue with the religious viewpoint discrimination was because the city had discriminated against Shurtleff based on a religious viewpoint. He was a Christian. He wanted to fly a Christian flag. And if I remember the case correctly, there were about 270 flags that had been flown by the city of Boston. Only one was singled out, discriminated against, and that's because of the religious symbolism that was on the flag. But it was a viewpoint discrimination based on religion, which goes to the issue of unilateral no-fault divorce. If two people get married in the church and they both take a vow to God, and their marriage is seen as being either out of obedience to Christ or for some reason like that, they've taken a vow to God. Why is the state getting involved in this? This is a religious issue. I don't know Mark at all at this point. I will be meeting with him or sometime in the future. But I'm very interested to find out if this also is a religious viewpoint discrimination. Maybe it will come up further as I read along here. But the issue with no-fault divorce is that the state will always, without exception, there are no exceptions. Oh, there may be one or two exceptions. We have to put one or two exceptions in there just to show that we're not completely biased and completely discriminatory. But when you have well over 99.999 divorce cases being granted in favor of the person who wants a divorce, even if the other party contests it and says it's not true. Something is wrong. The state is engaged in viewpoint discrimination. And once again, if you do this from a religious perspective, this is religious viewpoint discrimination. Boston has already lost that case. Will Massachusetts lose this case regarding viewpoint discrimination against the institution of marriage? And just so that you can see here and so that you know, this case was filed February 15th, 2023. So this is a very recent case that's going to be heard.